My name is Bob Schiffmacher. I'm chairman of the State Board of Equalization. Today is October 5th, 2023. We are in Las Vegas. There are members of the State Board of Equalization who are attending by Zoom. To my right is Tim Morris on Zoom, a member of the board. On Zoom is Al Plank and Tyree Gray are both members of the board. Sam Taylor is the attorney assigned to us by the Attorney General's office. He's also attending by Zoom. To my left is Kelly Langley, and I'd like her to introduce her staff.
Thank you, Chairman. We have Shaylee. I'm sure you'll be able to see her, but Shaylee as well as Christina Griffith on the in the Carson office at LCB, and then there is also let's see, Yvonne. I'm not sure which office you're in. Thank you, Shaylee. Yvonne Navarez-Goodson, Executive Deputy, and she is also on Zoom. Thank you.
So to open the meeting, I'd like to first of all ask for any public comment.
If there is anybody on the Zoom who has public comment, if you would like to raise your hand or hit *9 if you're on the telephone. If you are in person, just please come up to the podium.
Seeing and hearing none, I'll continue. We're closing public comment. There's a few items of decorum that I'd like to address. These are rules for public hearings. Number one, do not talk when members of the State Board of Equalization are talking. Do not speak unless you have permission of the chairman. When the chairman gives you permission to speak, speak to the members of the board, not to anyone else. Do not raise your voice or act in a hostile or aggressive manner. Do not speak down to, demean, or harass anyone in the proceeding or in the meeting. If you want to move from behind the table, ask the chairman's permission to do so. Handouts such as evidence must be handed to the State Board Coordinator for delivery to the State Board members. Do not interrupt anyone. Do not argue with the chairman, State Board members, or parties to the hearing. Do not speak, make noise, or gesture with your body when speaking. Those are kind of general rules of decorum, which we would like to general rules of a decorum to keep the meeting in line. Sam, if you would administer the oath to the parties in attendance and those that are on Zoom, we will endeavor to ensure that anybody who speaks before us will be sworn in.
Thank you, Mr. Chair. It would be helpful if we could see everybody who is going to be a witness raise their hand. Is that possible?
I will attest to that everyone in this meeting room is raising their hand.
Except you and me.
Except you, Tim and myself.
That would include those of you online. Thank you for letting me see that. I appreciate that. Okay, everybody, please raise your right hand who is going to be a witness or a party. Do you swear to tell the truth and nothing but the truth?
I do.
Okay, you're all sworn, and you'll be sworn throughout the course of the meeting. You do not need to be resworn. Thank you.
I'm assuming that everybody has had an opportunity to have review a copy of the agenda. There's an outline of the progress or the way the meeting's going to be conducted. When we call each case, the assessor, regardless of whether they are the petitioner or respondent, will provide a brief orientation as to the location and nature of the property at question. There will be a presentation of not more than 15 minutes by the petitioner, subject to questions from the board. There will then be a presentation not more than 15 minutes of the respondent, again, subject to questions of the board. and then there will be a 5-minute rebuttal by the petitioner, again, subject to questions of the board. We will then close the hearing for deliberations, which will be done in public, and then a ruling will be, we'll vote between the board, and that will be our ruling. Have I forgotten anything?
No, sir.
Kelly, if you would call the first case. Oh, I know that this is a pretty large agenda, but for the sake of keeping it straight in my mind, we're going to take them pretty much in the order that they are presented on the agenda.
Thank you, Chairman. For possible action, hearing on case remanded from the district court. You want me to say that?
Yes.
William Allen Goldap, Jr. versus the State of Nevada. State Board of Equalization remand from the 8th Judicial Court of the State of Nevada, Department 26, District Court. Case number A22-859548J, regarding order granting petition for judicial review. Remand ordered February 22nd, 2023. Thank you.
Okay, would the assessor's office please identify and orient us to the property?
This is Melody Garfield with the Clark County Assessor's Office. The subject property is an exceptional quality custom home located in the guard-gated neighborhood of Anthem Country Club. It was most recently acquired by the appellant in June of 2021 for $5.2 million. If you would like to see the property, there is an MLS listing and photographs for the property on pages 138 through 143 of the original SBOE case file. It's an exceptional quality 2-story home with...
For the purpose of the orientation, I think that
I don't need to describe it any further.
I think that that provides enough of the orientation. Mr. Goldap, I believe, since this is a remand, I believe that you're in the position of the petitioner, and so you will be offered your 15 minutes at the beginning.
Thank you. For the record, my name is William Goldap Jr. Can you hear me?
I can, but is
Okay.
your mic on? Okay.
Yes, sir. It's on.
Thank you.
My name is William Goldap Jr. I am the petitioner in case number 22-106, and I am the owner of the subject property at 17 York Ridge Court, Henderson, Nevada. I have received, of course, the notice of hearing that is dated September 22nd, 2023. Before I get into that, I want to first draw the board's attention to its notice of decision dated September 14th, 2022, based upon the hearing that we had July 20th, 2022, which is the document right before me. I'm sure you have it as part of your file. Now, the first thing, and I think this is the crux of the entire hearing this morning, if you will direct your attention to findings of fact number 2, it states, the State Board is mandated to hear all appeals of property tax assessments pursuant to NRS 361.360, NRS 361.400. For the sake of speed, I'm not going to use NRS here and after. I'm just going to recite the numbers of the statute. So let's take a look at 361.360 and 361.400.
Can you refer us to a page in the file that we can see that information, or?
Yeah, you're talking about your notice of decision?
Yes.
ROA 303. 303.
Thank you.
You got it?
Yep.
Okay. So, and you can,
It's on the right place. Notice of hearing.
Look at the original case file.
There's board members that can't hear you online.
okay, thank you, thank you.
Yep. That's 306 pages.
Okay.
Okay, I'm sorry.
Okay, so let's, I'm just going to, a brief recitation, just for the record's sake, of what these two statutes say. So firstly, 361.360, subparagraph 2, all such appeals must be presented upon the same facts and evidence as were submitted to the County Board of Equalization in the first instance, unless there is discovered new evidence pertaining to the matter which could not by due diligence have been discovered before the final adjournment of the County Board of Equalization. The new evidence must be submitted in writing to the State Board of Equalization and served upon the county assessor not less than 7 days before the hearing. 361.400, no appeal should be heard and determined save it upon the evidence and data submitted to the County Board of Equalization unless it is proven to the satisfaction of the Board of Equalization that it was impossible in the exercise of due diligence to have discovered or secured such evidence and data in time to have submitted the same to the County Board of Equalization prior to its final adjournment. Now, it is self-evident the three reappraisals that we're here today to consider, these reappraisals were not in evidence before the Clark County Board of Equalization. They were not in evidence before the State Board of Equalization. How do we know this? The order from the petition for judicial review says, with respect to the petition for judicial review pursuant to NRS 233B.135, the district court found that the petitioner was not provided with the information related to the Clark County assessor's determination to increase the assessed and taxable valuation of three comparable properties used by petitioner to support the petitioner's argument that an inequity existed pursuant to 361.356. So what the state and county are endeavoring to do today is to present evidence of the reappraisals of three properties, comparable properties, that I used at the 7/20/22 hearing, specifically comparable property number 1, to show that there's no disparity in value. My position is they cannot do that because the statutes 361.400 and 361.360 prohibit it. Now, I know what the retort's going to be. The judge ruled it. Just because Judge Cherry at the petition for judicial review said, yeah, send it back down there, doesn't make it so, because to do so, you would be subverting what these statutes have to say. There's only one other way the state and county could have gotten the evidence of reappraisals back down to the State Board of Equalization, and they didn't do it. That is NRS 233B.131, subparagraph 2. Bear with me for a second, I'll recite it to you. Well, paraphrasing it, it says that a party must file an application with the court and submit evidence as to why it was not able to present, why the county was not able to present evidence to the State Board of Equalization at the time of the original hearing. The issue is the state and county at the petition for judicial review, prior to the hearing for the petition for judicial review, never made such a request. And so when we went to the hearing on the petition for judicial review, they were not able to, there was no request to send the case back down. Now, Judge Cherry, when he heard the petition for judicial review, said, petitioner, me, I won. We've got the order saying that, and we're going to send it back down to allow me to address this. Well, the statute that he did so under, and it's noted here, you all have noted on your notice of hearing, is 233B.135, subparagraph 3, which then has 6 provisions underneath that. The provisions underneath that, that allows him to remand it, they do not provide for remand based upon newly discovered evidence. They provide, let me just, I had the statute right here. Oh, okay. 233B.135, which is why we're here back today, because of the court's ruling. The court shall not substitute a judgment for that of the agency as to the weight of the evidence on a question of fact. The court may remand or affirm the final decision or set aside in whole or in part if substantial rights of the petitioner have been prejudiced because of the final decision of the agency is, and we now have 6 reasons that if you, the State Board of members, at the original hearing did one of these 6 things, then the court can find, or the court can say, we're remanding it back to you so you can correct your mistakes. So what are the mistakes that you could have made? Violation of a constitutional authority of the agency. That's not and my petition for judicial review, I made no allegations that I wanted to be sent back because of the reappraisals. I made allegations based upon the standard review on other things, but not because of that. But the 6 things in violation of constitutional or statutory provisions, in excess of the statutory authority of the agency, made upon unlawful procedure, affected by other error of the law, clearly erroneous in view of the reliable, probative and substantial evidence on the whole record. That was the basis why I wanted the petition for judicial review granted in my favor, because I'm alleging that you, the State Board of Equalization, erred. Arbitrary or capricious are characterized by abuse of discretion. So, in reading those 6 provisions, what Judge Cherry said about sending it back down for additional evidence, it doesn't comport with the statute. And so it is not appropriate. So where does that leave us here? I know the state and the county want to get this thing back here so they can clear up any ambiguities wherein the value of the total taxable value of my property is less than these comparables, which would indicate an inequity. I'm saying you cannot consider that because of 361-400 and 361-360. So where does that leave us? We're right back to square one. At the Clark County Board of Equalization, my property was assessed at $4,925,753. And I'm only going to refer to Comp 1. Comp 1 was assessed at $2,226,444.
You have 5 minutes left.
Okay, thank you. The 2 properties, and so as we well know, it's well recited, my basis for appeal is 361.356, and the statute says under 1A, an owner of a real property, the secured tax roll who believes that his or her property was assessed at a higher value than another property whose use is identical and whose location is comparable may appeal the assessment. So I've satisfied all 4 of these things. Same location, identical use, it's another property, and value. And the key word here in the statute is value.
I'm sorry, can you remind?
That appealing is 361.356. That's the equity statute that we're basing this thing on. Now, on subparagraph 1A of 361.356, the word value is the critical number in here, or the critical word, excuse me. Value is defined by statute under 268.624, and it reads, value means the assessed valuation for purposes of taxation as established by the most recent tax roll, which has been extended by the county auditor. So based upon your notice of decision, you found the two things: my property at $4,009,000, comp one at $2,226,444. There's no dispute on that. There can be no variation on that. So the only other thing that you had was that my property is a house that's 9,469 square feet, sold for $5.2 million, June 11, 2021. Comp one is a house that's 14,703 square feet. We're both on the same size lot, 0.54 acres. And as of July 20th, 2022, he was for sale for $8,880,000, which is also your finding of fact number 14. So we have two pieces of property, my property and another property. That other property is 5,000 square feet larger, and he is $3.6 million list price more than my property, same lot size. It is patently obvious, because of the disparity in these two facts, that there is an inequity exists. So going quickly to burden of proof. You stated in the conclusion of law, item number 8, I did not fulfill my burden of proof at that other hearing. You don't say what the burden of proof is, so I don't know it. But when we got to the judicial hearing, the petition for judicial review, the state and county said the burden of proof on me is clear and convincing. That's wrong. They cited 361.430. It's a wrong statute. That statute refers to 361.420, which is a petition for recovery of overpaid taxes. But even that statute says the burden of proof on the petitioner is clear and satisfactory. Clear and satisfactory. The proper statute is 361.410, which states the burden of proof is 361.410. That the burden of proof is clear and satisfactory. Why is this important? Clear and satisfactory is a much lower burden of proof than clear and convincing. So based upon this evidence, when you have these two houses that I brought to your attention, it is clear and satisfactory, if not absolute, that there is a huge disparity in valuations. His total taxable value is less than 1/2 of my total taxable value. So in conclusion, I know the state and the county are going to say, yes, but look back at 2018, the house was in poor condition, it sold for $2.1 million. It's irrelevant. It's irrelevant because the assessor valued these properties for the 2022-2023 tax year, and it's filed with a secure tax roll. And so what they did by them having filed it, it discounts all the other stuff because we don't know what went into it. Presumably, when they assessed the property, they took into consideration the property's current status, not what existed 4 years prior. So this board has two choices. If you follow the law that you have cited, you collectively have cited, there's no other conclusion you can come to other than the evaluation of my property is unfair, inequitable, pursuant to 361.356, and that 361.360 and 361.400 preclude the board's consideration of any amended or supplemental valuations that they're going to present here this morning. So, I think it is important for the board to consider what the law is versus trying to arrive at a particular outcome. I know what the county and state want to do. They want to keep the total taxable value of my house up as high as they can, because the total taxable value is reduced, then the total assessed value goes down, my taxes go down. They don't want to do that. I understand this. After 2 years of doing this, I know exactly what's going on. But I think it is important for the board to consider the rule of law and you may not like the outcome on this thing. Nobody may like the outcome. The state, county, nobody's going to like the outcome of this thing if my taxes get lowered. But what's important for the sanctity of this board, sanctity of the state of Nevada, follow the law. Thank you.
Board, at this point, are there any questions of the petitioner?
Yes, sir. What do you think the value of your property is?
I'm not an appraiser. I paid $5.2 million for it 2 years ago, and since I paid that amount 2 years ago, we have begun a real estate recessionary environment. When I bought it, the federal funds had the tax
Excuse me,
rate
sir.
at
Could I just have a number, please?
$5.2 million.
Thank you.
Anybody else from the board have any questions at this moment? Keeping in mind that we'll hear from the petitioner again after the assessor's presentation.
None from me, Mr. Chairman.
Thank you. Ty?
None from me at the moment, Mr. Chairman.
Thank you, Tyree. None from me at this moment either. We'll move to the assessor's presentation.
Good morning, Lisa Logson for the Clark County Assessor for the Clark County DA's office. So I think it's important to start back where this case started. So if you look at the county board's decision on page 298. So the county,
Of the original
of the
record.
original record. So in there, the county board determined that the evidence did not show inequity and that it did not exceed full market value, and instructed the assessor's office to reevaluate the taxable values of the other properties and make adjustments as needed for the next fiscal year. So then the appeal comes to the state board. The state board hears the same evidence, and during that time, the assessor's office had already went back and reassessed some of the comparables as directed by the county board of equalization to do. But this board decision was not based only on those comparables increasing. This state board's decision was based on a variety of things, which is outlined in your record of decision on page 304. And some of those decisions were that with custom homes, there's a variety of things to consider, such as the quality of the class, the materials, the amenities, unique features, lot sizes, locations, and views. And it was determined that the assessor's office treated this property the same as it did every other property and evaluating it using the Marshall and Swift method. Here, it's trying to be couched as if the increase that the assessor's office did based on the county board's decision is new evidence. And that is not the case. What happened is the county board found no equity, this board found there was no equity, and therefore the fact that the assessor's office increased those is not new evidence. It's evidence that this board can rely on and that should be considered, but again, is not the only evidence that was before the board to make their decision. And also, I'd like to point out in the equity statute, which is NRS 361-358, if the board finds an inequity, but first, the board didn't find an inequity, but if the board would to find an inequity, the board has two options. They can either reduce the taxpayer's property, or they can order that the property of the other values be raised. And so here, if there was, which again, the board didn't find an inequity, but even if there was an inequity, this board would have the ability to order the assessor's office to raise those properties. So while he's trying to couch this as a new evidence argument, it's not that there's new evidence, it's that he didn't get the result in which he wanted, which was his property to be reduced, which is not required under the law. And then in addition, the district court's remand was to allow the petitioner the opportunity to respond to those increased values. Did he have any other evidence or any other reason why his home was inequitable based on the other values of the property? But I think when you're dealing with custom homes, like in this case, there's such a wide variety, and it's not an apples to apples comparison. And so, which I think is, again, why the board had substantial evidence in finding that there wasn't an inequity, even outside of raising the three comparable properties that the assessor raised. So, Melanie, do you want to add anything about just the properties?
I just wanted to note that equity is also in the methodology that's applied.
Can you
And
state your
that
name
is
for
not
the record?
necessarily, I'm sorry, Melody Garfield with the Assessor's Office. The equity is in how we cost these properties, and we use a computer-assisted mass appraisal system. The costs are in there. If they have equal amenities, those amenities are costed identically. But with the custom properties, you're not going to have equality in the results because the properties are so very different. The equity in the results often applies to your sort of tract homes in subdivisions because those homes are more identical. But I just did want to note that the equity here, they found no inequity, and really the equity is in the methodology, not in the final results.
Board, do we have any questions for the Assessor's Office or the DA's DA? Hearing none, I have a question. So the county board's order was it acknowledged or it agreed that the methodology used to appraise the property in question, the subject, was appropriate. They determined that the methodology used to appraise the comparable properties resulted in an inequity and ordered or requested that those values be revisited. Is that correct?
Again, Melody Garfield, the first part of your statement is correct. Yes, there was no inequity in how the subject was appraised. What we determined and what we explained is that the comparable properties that were selected were comparables where obsolescence had been applied for a variety of reasons. One of them had been, you couldn't occupy it. It was sold very low, so we cannot exceed market value. So we had lowered the value. We had permits on the property. We were waiting for those permits to be completed so that we could add those improvements. It was not because the board told us to do it. We were planning on doing that anyway. Other properties, we had improvements on those properties that we didn't know existed. One property had a guest house, so we added that guest house. When it comes to our attention, we do add these improvements to the property. I'm not sure how these properties were selected by the appellant, but they tended to be lower properties, and for a reason. There were things on there that we didn't have, or there were condition adjustments that we were, planning on taking care of. And so what the board, getting to the second part of your question, what the county board said was, well, we do have kind of low sales ratios in there, and, it does seem like maybe there's an issue here with this 13,000 square foot property, so we need you to take a look at it. They didn't say, oh yeah, we've definitely got a problem. They're just like, we think it's a good idea if you look at some of these homes out here again and make sure that we've got all the improvements that we need to have and that we are costing them appropriately and equitably.
Well, I think that that's incorrect. The final action, it was moved by Member Canepa and carried by unanimous vote of the members present at the board, this is the county board, to accept the assessor's recommendation for the subject as the equity data did not exceed full market value, and they instructed so this is the instruction. Mm-hmm. The instruction is that the assessor's office reevaluate the taxable values of the other properties in the area. And from what I understand, there were changes made to those properties as the result of this decision. The state board's decision was the same. We mimicked or mirrored the decision at the county board, and so we had asked, as part of that process, that the comparable properties that were brought up by the petitioner be reevaluated as well as throughout the neighborhood to confirm or change their values to comport with the statutes and current market data. That's my understanding of what occurred in our hearings. The additional information appears to be just a confirmation that those actions have been accomplished. Is that correct?
Those actions have been accomplished.
Okay. Board, any other questions?
No, sir.
Any of our remote attendees have questions?
None here, Mr. Chair.
Thank you, Tyree. Al?
None here. No, clear.
Mr. Goldap, you've got 5 minutes as a rebuttal, please.
Thank you, Chairman. Listening to what Ms. Lugs and Ms. Garfield say, they are skirting and sidestepping the essential issue, and that is procedure. I know, what the county, Clark County Board of Equalization did in allowing them to go out and reappraise these comparables that I had selected. That's fine and well, and I do not have an issue with it. The issue that this board has to grapple with is that after they did that, have they now followed the correct statutory procedure? And it's obvious they have not. They could have, before the July 20th, 22 hearing, they could have come forward and said, we need an extension because we haven't had it done yet. Or they could have filed their motion and presented evidence why it wasn't done timely. They haven't even done it here. They still haven't even complied with 361.360 here by requesting that it be allowed. So we're talking about a matter of procedure which the state and county has not complied with. Just another thing, Ms. Garfield says equity is in the methodology and not in the outcome. And I would like to ask her, or ask you, where in 361.356 does that say that? It's just made up. You're making up arguments to try to support a position, but the arguments you're making up are not based in law. 361.356, you read it and it's very clear. And also she said appellant has selected lower valued properties. So I select one property, 3 Anthem Point, that sold for $10 million. That's twice as much as mine. I selected another one, 39 Club Vista. That sold for $8,250,000. Another $3 million more than mine. And I selected the one we're comparing, 11 Anthem Point. That was for sale as of the hearing for $8,880,000. Which brings me to one other thing, and I forgot to mention on my opening. Let's flip the script just for a second here. Let's suppose I want to bring to the board new information that, for instance, 11 Anthem Point is now for sale, instead of 8.8, it's for sale for $10,000,008. Guess what? I made a motion before Judge Sturman to allow me to present that evidence that 11 Anthem Point is now listed for sale at $10,880,000. You know what she said? No, you're not going to do it. It's evidence that wasn't presented at the Clark County Board of Equalization. It is exactly the same thing we're doing here. They didn't present, these reappraisals were not presented at the Clark County Board of Equalization. They were not, there's no motions made before the State Board of Equalization hearing. And so you're walled off from hearing that. There's procedurally, there's no way that the board can do this short of disregarding 361.360 and 361.400. And like I said, I know what the state and county want to accomplish, but it needs to be accomplished within the confines of the statutes. Otherwise, if we're just going to, if rulings are just going to be made, or if the state and the county are going to be able to do whatever they want to do and forget about the taxpayer, then all of these statutes, and I will say they're numerous and they're all are interconnected, and they're not necessarily straightforward to a layperson, me. If you don't follow these statutes, this whole proceeding becomes meaningless. And I think in this one instance, and I would implore the board, even though you may not like doing so, rule in my favor that my property, total taxable value, should be lowered commensurate to Comp 1, which as of July 20th was $2,226,444. And here again, I am dispensing, for the purpose of this argument here, I'm dispensing with any per square foot methodology that I used there, and you said we're not going to do it. Conclusion of law number 5 and number 6, we do not base our appraisals on our decisions on per square foot methodology. So I'm dispensing with that. I'm just saying, as a matter of equity, value me at the same value as 11 Anthem Point Court, which is $2,226,444. And that dispels the inequitable results. I mean, no doubt about it, these houses in Anthem Country Club, well, not all of them, but there's a select grouping of houses. They are big and extraordinary. And, obviously there's different means of valuing each house based upon the individual amenities. The board does not have to consider that. The only thing the board has to consider is what is the assessed value of the properties pursuant to 268, 624, which has been filed. I mean, it's way too complex, and there was no amount of time that you all could possibly go out and value my house. So the statute, the value, the 268, 624, it does the work for you, and you just have the value, and that's all you have to consider.
Thank you. Board, any questions or comments for the petitioner?
None.
None here, Mr. Chair.
Thank you, Tyree.
Yes, sir. The property that you want us to lower your value to, what was the address of that? Was that the 11 Anthem Point?
Yes, sir. It's 11 Anthem Point. If you will refer on.
No, that's all I want to know, sir.
Okay. All right. Yeah.
I think we're on SBE 5. Is that what you're talking about?
Pardon me?
SBE 5, page 5.
I've got the ROA, and it's 304. It's
Okay.
number 8 on your findings of fact.
Well, anyway, I'm looking at SBE 5, and it shows that property 11 Anthem Point Court. The current list price is like the $8,880,000 that you referred to.
Yeah, that's findings of fact number 14. I'm referring
And the total value at $2,226,443. And I believe the assessor's office has indicated to us that that's only a partial completion value. Is that correct?
Yes, that's correct.
And what percent complete is that?
Let me see. We had an adjustment on it. Let me look here.
And if you could refer me to a particular page, I'd appreciate that.
Yes, it was 75%, and let me just find the page for you. It's the PRC for 11 Anthem. PRC 165, I believe, page 165 through 167. And if you look down to the center, sort of towards the bottom of the page, it's highlighted. It says percent CMP, and it says 75%.
We're on page what?
165, SBE 165.
165. So we're looking at the cost approach that you have on that particular property?
Yes, this is the property record card.
Okay.
There were other things added to the property because we did not have them on the rolls. But that is the percentage we had it complete at the time.
Do you have any photographs of that property?
Yes. Let's see. Yeah, page 153 and 154. Oh, the pictures, I'm sorry, are on page 155 through 158. There was a historical sale of the property, so there's pictures in there for that. There's the recent listing, there's pictures for that. And then the property has since sold, but of course, that would be new evidence, so.
So while Tim's looking at that, I'm looking back at page 166. The obsolescence or percentage complete adjustment is that what I'm looking at when I look on the upper left-hand corner or upper right-hand corner of page 3 or page 2 under depreciation of $5,782,000? Is that the adjustment for percent complete and
Is this the page we're looking at here? 165, you said?
I'm on page 160.
That'd be 166.
166,
166.
page 2 of the assessment record. Building value summary.
Yes, I believe that's what that depreciation,
5,000,007.
5 million.
22. That's
Yes.
what you're looking at.
Yeah, I'm trying to divine the source of that information.
Can you guys make sure you're speaking into the microphone so our court reporter can't hear very well when you guys aren't close to it?
We need longer microphones.
you know, this is a property record card that we have, and I really can't say for sure what that depreciation number is for. I'm not sure what they combined there on that line. It could be the 25% obsolescence and the 1.5% depreciation could be combined there, but I really am sorry, I don't know. I don't know if maybe someone in my office does. It's on the property record card here. It says depreciation.
Jamie Jacobs, Clark County Assessor's Office, for the record. Yes, that would be the depreciation, because if you take the 7.3 million minus the 5.7 million, plus your extra features would equate to an RCN of 1.6 million.
Correct, but what's the source? What are the components of that $5,782,000 number?
Sure, so that's going to be all the depreciation based on the adjusted actual age of the property, as well as any percent good applied.
Okay, so that captures the incomplete nature of the property and the age life depreciation.
Yeah, the 25%, which would be percent bad, and plus the statutory depreciation.
Thank you.
Thank you.
So that accounts for the partial, I'm sorry, that accounts for the partial completion of the property as well? That's in the 5.7 million?
Yes.
Not yet. Not yet.
I'm done. I have no question.
Okay, please.
Just one comment, Chairman. Going back to what has been discussed over the last several minutes about the percentage of depreciation, I don't believe it is relevant because when the assessment for the 2022-2023 tax year, which is what we're concerned with, the house was already done. There was no, the house wasn't uninhabitable or in a decrepit state. The house was built out. The only thing that had not happened was the assessor just had not reassessed the house. So what they're doing is they're looking in the rearview mirror from 2018, 2019, 2020, 21. But what's relevant, only relevant to this hearing, is what was existent for the 2022, 2023 year. I'm not going back and trying to get my property reappraised value, only the year of 2022, 2023. And so you just look at what was filed with the assessor's office on 11, and it's there. There's no allowances for anything else. The house was done. The house was for sale for $8,880,000 at the same time I bought my house. I mean, the 11 Anthem Point was for sale for $8,800,000. Actually, it was $9,880,000 in June of 2021. You wouldn't be selling a house for $9,800,000 in June of 2021 if the house was in a state of disrepair. So they're requiring you, or they're wanting you to look backwards to what happened historically. We're not concerned with that. We're only concerned with this narrow slice of time. They don't want to consider that because to do so, renders my proof positive on this thing that there inequity exists. So that's my conclusion there.
Okay, members, any further questions or comments of either party? Hearing none, I'll close the hearing for deliberation. I will take the first comment, although typically I don't. NRS 361, 356, item 3 gives the board two choices if they find an inequity that exists in the assessment of the value of land or the improvements. The board can add or deduct from the value of the land or the value of the improvements, or both, either of the appellant's property or the property which is compared to equalize value. During our hearing, it appeared to me, during the county's hearing and during the state hearing that we participated in, it appeared to me that we concluded that the property in question, the methodology used was appropriate. The order or the decision that we had made was that there was, in fact, the potential for inequity between the subject property and the comparable properties that the petitioner brought to us. And in accordance with 361, 356-3, we ordered or asked that the competing properties be reevaluated, and if in fact there needed to be adjustments, those adjustments would be accomplished. The balance of the argument, I think, falls under the category that, the answer, that's not the course of action the petitioner had requested of us, but it is the course of action that we took, and I believe that, personally, I believe it was the appropriate course. Any comments from the rest of the board?
I guess I just have one question for
Go ahead,
Sam. Is there anything in the remand order that we need to make sure and address?
Yeah, this is Sam Taylor from the AG's office, for the record. No, I don't think there's anything the board has to necessarily consider. It was clear from the judge's remand order that the burden was on the petitioner in this case to basically take a look at and evaluate the impact of the comparables that he had proposed. And there really wasn't a lot of discussion on that particular point, so the board can take whatever discussion the petitioner offered and apply whatever value it wants to that.
Okay, thank you.
Tyree, any questions?
None from me at the moment, Mr. Chair. I'm inclined to agree with the synopsis that you just gave.
In that case, I'll entertain any further comments or a motion.
Did the assessor's office change the value on the property on the number 2?
I'm sorry, you're asking if we changed the value on another comparable? Do you have the address?
Yeah, the one of the comparables that we've been talking about, the one at the...
Anthem, the 11 Anthem, yes, we did change the value on that one, and also on 39 Country Club, or I'm sorry, I have them here. Anthem, on also 3 Anthem Point, 1 Aubrey. There were several properties that we changed the value. We reevaluated.
Did you lower them?
No.
You
we did
raised them?
not. Yes.
That's all I have, sir.
Again, I would entertain further comment, deliberation, or a motion.
Mr. Chairman, I'll make a motion that we deny the petition. I believe that the information that's been supplied by the assessor's office indicates that the assessed valuation does not exceed fair market value, and that there is equity that does exist now that the other properties have been adjusted.
Do I have a second?
Second.
All in favor signify by saying aye.
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 Any opposed? Hearing none, motion carries. Thank you all for participating. Kelly, if you would call the next case.
Item D for possible action, recommendations by the Secretary to dismiss taxpayers' appeals pursuant to NAC 361.7014, appeal of the 2023-24 secured roll, the 2022-23 unsecured roll due to untimely filed, determination of jurisdiction of State Board pursuant to NRS 361.155 sub 6. The first item, Chairman, is case 23-143, Joseph Vrisella. Notice of appearance is on page 21 of the package. This should have gone before CBE.
The, yes.
And this is Christina Griffith. Just for the record, I know with you guys all being down there, the court reporter is up here. So just to make it a little easier on her, even if you've already stated your name before, each time you speak, could you please state your name so she knows who's talking?
Does that count for the board members as well?
No, I think she's
Christina?
got you guys down, but just for the assessors and the appraisers who come up and the taxpayers, if you could please. Thank you.
Thank you. Assessor, would you identify and orient us to the property, please?
I believe this was an exemption.
Can you introduce yourself,
I'm
please?
so sorry. Mary Ann Widener with the Clark County Assessor's Office. I believe this was an exemption that was filed and it was denied by our office by the petitioner who lives at the fiscal address 928 White Feather Lane, Las Vegas, Clark County. They did not file to the county, and I believe they just filed directly to the state.
Is the petitioner in attendance?
Yes.
Please introduce yourself and speak up for the court reporter, please.
Yes, my name is Joseph Ursella, and I did file a petition directly with the state, the Nevada Board of Equalization. The reason why I filed a petition directly with the state, after a number of phone calls with the Clark County Board, I tried to get an appeals form with respect to the decision they made with regarding my exemption. They would not provide me with an appeals form, and they only left me one alternative, that is to file with the State Board of Equalization.
Any questions for the petitioner?
Hello, it's Tyree Gray for the record. So, petitioner, so is it your testimony that you were unable to access a public document via any other source? No Google, nothing like that, that the only way was to access it directly through the county?
Again, this is Joseph Ursula. It's my understanding, well, I did try and access through Google initially, and I couldn't locate a application form. I was under the understanding that the Clark County Board would have to issue me an appeals application form, and they would not do that.
And petitioner, do you have anybody, do you have any records of whom you may or may not have spoke with and on dates?
Yes, initially I called the board on November the 8th, 2022, and they indicated to me that petition forms would become available roughly around the second week of December 2022. On December 21st, 2022, I spoke with Greg Foster of the Clark County Assessor's Office. He indicated I could not file an appeal with the Clark County Board of Equalization. He also further stated that I must work through my assembly person with respect to resolving this issue.
Thank you. No further questions from me, Mr. Chair.
Do you have any further questions or comments before we turn the hearing over to the assessor's office regarding the late filing? Mr. Versilla, do you have any further comments for the board regarding the late filing before I turn it over to the assessor's office?
No, I do not.
Thank you. Marianne?
Marianne Widener for the Clark County Assessor's Office. My first question is, was this filed timely to the State Board? Because I believe it was noticed on here because it was not filed timely to the State Board. I'm not sure if that's the issue at hand or if the issue is truly that they didn't file to the county first.
This is Christina Griffith for the record. They did file timely to the State Board, they just did not file with the County Board.
Okay, thank you. I have no record of this conversation that this gentleman had with any person in our office. I will tell you that we do our best to make sure that they do have to request an appeal form from the Clark County's office when they want to file to the county. That is because we keep track of our forms. We number them to make sure we have enough resources available and enough hearings available because we need to know how many cases are potentially going to come forward. With that, we do require them to file, and the statute requires them to file no later than January 15th. And for this year, it would have been January 15th, 2023. So it may have been that if that time frame had passed when he was having the conversation with the person in our office, that they told us that they told him that there was no longer, it was past the time frame for him to be able to file. And that would have been the reason why he would have been denied, because had he done that, he would have just gone for a notice of appearance before the County Board of Equalization because it was already past the deadline for filing. Usually if somebody is asking on the day of and we're within a day of or 2 days of or 3 days of, we will do that. But if they ask us 2 weeks into the hearings, we know it's well beyond the time frame, and we have already scheduled all the hearings because we have to book them in advance of when, because of the timing of noticing for the hearings and doing all the things that are required. So I don't know what the conversation was. I'm not privy to the conversation that this gentleman had. But if someone from our office said that, they most likely said that because we were well into our hearings at that point and we were well beyond the deadline for filing an appeal to the county.
So the petitioner asserts that he had a conversation on, I think it was November 8th, 2022, and then again in December of 2022. Those conversations were prior to the filing date, which for the county, which you said was January 15th, 2023.
Yes, I'm not denying that he probably did have conversations. When we do have lots of people that do call, when I say lots, not a lot, but there are a handful of people that will call in November prior to our notice of value cards going out and prior to the final decisions being made for whether, in this case, it's an exemption case. And because our notice of value cards have not gone out yet, and so we do not even have our database ready and open to give them a new form for that coming year. So we tell them to please call back, once they receive their notice of value card, or, in mid-December, early January we will get a form to them. I understand this gentleman has testified to that. If he had something in writing, he could show us an email that said that he had requested the form. I wouldn't be here having this conversation with you today. We would have done something to adjust it, and we would have asked the state board to consider it potentially because we missed something. So barring that, I have no record beyond his testimony saying that he had this conversation. If he had had the conversation with somebody in our office and we were prior to the deadline date, we would have certainly given him an appeal form and allowed him to move forward with his appeal.
Petitioner, you have an opportunity to rebut what the assessor said, and then we will ask any questions and close the hearing for deliberation of this question.
Again, this is Joseph Ursella. The only evidence I have is the recordation that I have in my file with respect to my conversations. I just didn't have a real positive experience with the Clark County Board of Equalization with respect to listening to my initial facts regarding my case, and relied on them with respect to phoning in to get a application for appeal. There was no provision ever stated to me, either in an email that they sent to me, or in other conversations, that I should have sent an email for a direct petition with the Clark County Board of Equalization. The only thing they ever indicated to me in my conversations with them, these are the steps you need to call in December with respect to getting an appeals petition. And really, that's all I want to do. If I have to be heard by the Clark County Board first, I'm willing to go there with my information and my interpretation of the statute. But I'm here today because they just didn't pay any attention to me with respect to my position regarding my veterans exemption. And I believe the information I provided and the statute I'm looking at is fairly clear cut. There's only two items that I have to meet, and I believe I've met both of them. I believe I've provided enough evidence with respect to that. So if this matter can be adjudicated here, I certainly appreciate it. If it has to go back down to the Clark County Board of Equalization, I'll follow whatever direction you provide. Thank you.
Board, are there any questions for either of the participants in this hearing?
Mr. Chair, Tyreek Gray here.
Yes.
I would ask of the county, on what day did it sounds as though the county controls the process, and so my question would be to Ms. Widener, on what day did the appeal forms become available for public dissemination?
I don't have the specific day. I believe it was somewhere around December 4th or between the 4th and the 15th, because December 15th is the deadline for us to publish the roll or have the roll completed. And so it would have been somewhere between those two timeframes. And as soon as we publish the roll, we have it available for us to send out appeal forms. I know that's not the question you asked me, but and it's other evidence for his actual concern with not getting the exemption. But I do want to state that our our office has been in continual communication with this gentleman with regards to getting us the appropriate information that we needed so that he could qualify for his exemption. And so there are emails that went back and forth regarding that, but if he had requested appeal form, he could have requested one via that methodology. And that information is in your materials that he submitted. So I just want to, but I don't want to open up the case with regards to his exemption. I just want to say that if there had been communication with regards to asking for an appeal form, we were still working with him, attempting to try to get the information we needed way back in September of 2022 to try to get him what he asked him to get us what we needed so he could qualify for the exemption. So our office has been in communication with him. It's just that we didn't get what we needed to get. And there's nothing in that documentation that shows that he had requested appeal form that I can see. If he can provide that to us, I'm certainly willing to look at that, and we would ask that the board potentially would remand that to the county or postpone it here and we could address the other issues. But I just don't see any of that information. And again, this is just somebody's word saying that we said certain things. So.
Mr. Chair, Terry Gray here again for the record. So what I'm hearing you say is that there were communications that went back and forth, but those communications were in September, and so the form would not even have been available to a petitioner in September. It wouldn't have become available until much later, somewhere in between the dates as you've given December 4th through December 15th. Correct?
Mary Ann Widener, for the record, that would be correct. But I did only pointed to those conversations to let you know at that point in time, there was still time for us to resolve his concerns. And we were trying to work through resolving his concerns so that the board understands that we have not ignored this gentleman, that we have been trying to address the concerns he had. And we were asking him for some specific information, which he did not provide.
Mr. Chair, no further questions for me.
Thank you. Al, any questions or comments?
No.
Tim?
Did he file the right form?
I'm sorry, pardon me, Chairman, Mr. Morris, can you tell me again what you're asking?
When he filed, did he file the correct form?
For the State Board of Equalization or for the exemption?
Both.
He filed the appropriate form, but the form must, for the exemption, and I don't know if the board is wanting to open up the conversation about the exemption, if that's what the chairman wants to do. But he did file the appropriate form. He just didn't provide the information that he needs to with the form that is required for us to grant him that exemption.
And you went back to him and asked him to do that, and he didn't respond? Is that what you're telling me?
That is correct. And the email is in there where we requested for the appropriate information.
What page is that on?
SBE 14.
So you sent him an email was that the September one or the July one? Oh, you sent him this in September.
That is correct.
And then he replied in July? September? Yeah, he says attached is a PDF containing the affidavit that was sent in on July 25th.
Are you wanting to get into the material aspects of this case?
No. It's my understanding we're trying to verify the timeline to determine what action we need to take today, whether, I think, isn't that correct, Tim?
Yeah.
In terms of accepting, the first question is accepting jurisdiction, because this appeal was filed to us in error, or not in error, but it did not pass the normal sequence of events. The normal sequence of events would have been to be filed at the county level, and whatever their decision would have been, then we could have addressed that if necessary. So I think that, if I'm paraphrasing, but I think Tim's trying to make sure that he understands the sequence of events that got us to the point that we are now in terms of accepting or denying jurisdiction. Is that
Yes.
correct?
Lisa Logsmith with the District Attorney's Office, just to provide some clarification. So there's an application for the exemption that goes to the assessor's office, which that is your affidavit of veterans exemption, which was submitted to the assessor's office on July 25th of 2022. So, and then if you go to those emails that you're discussing on page 14, that is where the assessor's office is essentially denying the exemption, that they don't have enough information there to move forward. And so at that point, the exemption's denied, and the taxpayer would have the ability to appeal the assessor's determination to the County Board of Equalization. And that's the form that didn't get submitted. And so that's kind of the procedural. And instead, now you have a direct appeal to the State Board of Equalization that runs afoul of the fact that it needs to go to the county board first.
Okay, board, any further questions of the participants?
None here, Mr. Chair.
None here.
Well, during these email transmittals that we have, did the assessor's office provide the taxpayer with the proper form?
Are you referring to the appeal form?
The proper form for whatever he had to file to obtain the exemption or to get on the county board of agenda? Was he, I don't know if he asked for those forms, or I know you're trying to help the taxpayers here. I'm just wondering about, I think when you sent out other notices to like agents telling them, you need to have a particular form, you supply that with the email. I'm just wondering, with these emails we're going back and forth with this gentleman, did you provide him with the proper form to fill out, or direct him to the proper place to obtain that form?
First, we do not provide the forms to anyone unless they request them. They have to request them from our office. And so we would have only provided the form to him if he requested it. If he and he is claiming that he requested it, but my concern is the timing of when he requested it. If he requested it after the deadline, we would have not provided him the form, because it would have already been past the deadline for filing an appeal to the County Board of Equalization. And at that point in time, we would have directed him to say, if you want to file an appeal, perhaps file it to the state, and then the state would have to decide whether they were taking jurisdiction, because we were beyond the time frame for filing to the county board at that point. Again, I can't make assumptions of what happened. We're only going off of this gentleman's testimony as to what he said happened when he came to our offices. But we are not in the habit of denying people appeal forms. If they call, they can call and request it. They don't have to even come into our office, and they literally give us their email, we put it in our system, and it emails it to them immediately. So we have a pretty good, efficient system of getting those forms out as soon as they're requested.
Okay, if there's no further questions, I'd like to close this for deliberations. The question at this point is whether, the only question at this point is whether the State Board of Equalization accepts jurisdiction of the case. Not any, there's no other question on the table at this moment.
Mr. Chair, this is Tyree Gray for the record. In deliberation, my sentiments are these. It appears as though there were communications between the petitioner and the county that happened between July and September, with an adjudication that the petitioner didn't meet the qualifications for the veterans exemption. Per the petitioner's testimony, the petitioner made at least 2 phone calls to the county, and per the county's testimony, there is a time frame upon which these documents become available. So a petitioner called twice, and he did so too early. It almost becomes the system is set to where the petitioner needs to apparently call within a window of time that the county can even actually determine and say, hey, call on this date and we'll have the form ready. Because of that, I believe that both the petitioner and the county both said that they were willing to accept a remand of this case. And it is my thought that this case actually does belong before the county. And so if us denying jurisdiction, but for the only way that I would be willing to deny jurisdiction is that if the county were to agree to actually hear this case, but if they are not in the position to do so, then it would be my thought that we would accept jurisdiction of this case because it seems to serve equity.
So if I understand the process, if we deny jurisdiction, that's the end of it. It does not get remanded automatically to the county. We would have to accept jurisdiction and then make a motion that it then be remanded as a separate action. Does that seem consistent with you guys, your understanding of the process?
I believe that's a Sam question. I don't want to institute my legal knowledge in place of that of Sam's. Sam, would you mind weighing in just on the procedural?
Yes, Sam Taylor from the Attorney General's office. I think Bob is correct that you would have to accept jurisdiction and then choose to remand. That would be something I think would be consistent with what the testimony was presented today.
Thank you,
Chairman.
Sam. Mr. Chair, Tyree Gray here. Sorry. For the record, understanding that that would be the procedure, based upon what I said, then I'll withdraw my comments and say that I would lean toward accepting jurisdiction in order to be able to facilitate a remand to the county.
Do I have any further comment or a motion?
Yes, Mr. Chairman, I make a motion that we accept this particular appeal, to accept jurisdiction so that we can remand it back to the county.
Mr. Chair, Tyree Gray for the record. I second.
I will call for a vote. All in favor signify by saying aye.
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 All opposed? Hearing none, the board will accept jurisdiction. I agree with Tyree in that the question to be considered at this point merely, I do not want to have the State Board of Equalization be in the position of rendering a decision on the exemption. I would prefer that any motion or any discussion be related specifically to a remand to the county level to complete the process. It has been brought to my attention that the county board has closed their season. It would require a reopening of the county board at substantial expense. I don't know that that's a consideration, but I don't know whether there's a way to address this issue in a way that would not be overburdensome to the county. I just don't know what the answer is. I see Jeff Mitchell raising his hand. Jeff, do you have any comments or questions?
Thank you, Jeff Mitchell, for the record. I don't know if the county and the petitioner would both be reasonable or agree to it, but perhaps it could be remanded, but heard during the February hearings that the County Board of Equalization will reconvene on. It would just be having jurisdiction for a prior year, and that they could consider that case then. And that way, we're not that far removed. And if it then needs to be appealed back up to us, we could hear in the normal course of business.
Thank you, Jeff, for that clarification. So the petitioner at this point, we have accepted jurisdiction. You've got a period of time to make comments, and then Mary Ann will make comments, and then you'll have a rebuttal. It seems to me that both of those actions could occur pretty concisely, but according with our
Mr. Chair?
policies, each of you would have 15 minutes if you needed it.
Mr. Chair?
Yes.
Yeah, Sam Taylor for the record, again, from the Attorney General's office. I would note maybe for the record that you could potentially avoid the need for discussion on this issue if Mr. Vercella was amenable to having it remanded back to the county level.
This is Joseph Ursula. I'm fine with it going back to the county level for a hearing, and if that's in February, I'm certainly okay with that, as long as the county is willing to accept my participation in their February hearing.
Mary Ann Widener for the Clark County Assessor's Office. Yes, we are agreeable for the remand.
Board, do I have any comments or a motion?
Mr. Chair, this is Tyreek Gray for the record. For cleanliness, I would. It appears that the petitioner has the county's attention, and the county has the petitioner's attention, and so it would be my hope that the two would be able to resolve this even before it would need to go to the county board. But with those brief comments, I would like to make a motion that that we have accepted jurisdiction and that we will remand this case down to Clark County for potential and possible hearing and resolution on their February agenda.
I'll second that.
All in favor signify by saying aye.
Aye.
Aye. Any opposed? Hearing none, motion carries. I'm hopeful that the two parties can come to a resolution and maybe come to the county board in January with a stipulation, if that works for everybody. We've been at it for a couple hours. I'd like to take a 5-minute break, let the court reporter rest her fingers, and we will reconvene in about 5 minutes. Thank you.
Recording stopped.
Okay, everybody. Our 5 minutes has turned into
Recording in
about
progress.
14. So we're going to reconvene. Okay, Kelly, could you introduce the category, item D, and then we'll discuss how we're going to address the cases involved, or the remaining cases.
Thank you, Chairman. Item D for possible action, recommendation by the Secretary to dismiss taxpayers' appeals pursuant to NAC 361.7014, appeal of the 2023-24 secured roll, along with the 2022-23 unsecured roll, untimely filed, determination of jurisdiction of State Board pursuant to NRS 361.155 sub 6.
Thank you. It's my understanding that the remaining cases in item D, case 23-144 through 23-167, are all interrelated. The issue is the same. The representative of the property owners is the same, and of course the assessor is the same. The question at hand is, the first question is whether we accept jurisdiction on this group of cases. In the final motion, we will list them individually by number for clarification. At this point, it's the opportunity for the assessor to provide a brief orientation as to what these properties are. And
hi, good morning, Board. My name is Daryl Prawalski, Prawalsky, for the Clark County Assessor's Office. Generally, what these cases are for is a Circle K convenience store. Some of them also have fuel sales. Some of them do not. But each one of these is a convenience store located in Clark County.
thank you. Petitioner, do we have the petitioner on Zoom?
The representative is Sally Paul.
Ms. Paul,
Sally,
you can
can
go
you-
ahead and unmute your phone. It's *6 to unmute. Ms. Paul, I see you on the Zoom on your telephone. It's prompting you to unmute your phone. You need to hit *6 to unmute.
Mr. Chair, this is Sam.
Sam, go ahead, please.
Yes, do you intend to make a motion to consolidate these cases? Or are you just doing that as your authority as the chair?
I would like to hear from the petitioner at this point to determine whether, in fact, the issues are the same and warrant consolidation.
Okay.
Does that make sense?
Thank you very much. Yes, sir.
Thank you.
Christine, this is Kelly. Do we have the representative Sally Paul on the phone? Are we trying to get them connected on Zoom?
She is connected on the Zoom. It looks like she's on the phone. She just emailed me and said that she is trying to unmute.
Thank you.
Hey, Christina, is it possible to send the petitioner an email asking if we can consolidate these cases while we're trying to deal with this connection issue?
Can the board hear me now?
Is this Sally?
Yes, it is.
Super. The purpose of this section of the hearing is to determine jurisdiction. It's not to hear the individual cases. So this is your opportunity to make your argument that we should accept jurisdiction, although the filings that we see are beyond the deadline. So it's your opportunity to make that case.
Yes, sir. Yes, this
And
is Sally Paul. I'm with Delta Advisors in Texas. I have the next 24 cases on the hearing schedule for appeal. I would like to bring to your attention the PDF of the actual filing. The taxpayer
Sally, could
petition
you
for
speak
appeal
up a
form,
little bit louder?
the decision of the
I'm sorry, could you speak up just a little bit louder, Sally? It's a little hard to hear you.
Yes, ma'am. Can you hear me now?
I can hear you. Let me ask a real quick question. The issues on these 20 some odd cases are the same at this stage. Do you have any objection to consolidating the discussion as it applies to to all of these cases?
I do not. If you see page 5 of each of the filings in the PDF, the taxpayer petition for appeal form from the decision of the County Board of Equalization, I specifically highlighted at the top that the deadline was March 10th, and it must be postmarked by March 10th. If you get on to page 5, you can see the actual certified mail envelope from Clark County Clerk sent to myself with the decisions of the board dated March 9th. They mailed these to me March 9th. You can see on page 5 that the first notice that I received to pick these up at the post office was March 13th. And these were sent out in the mail on March 15th after a discussion with Christina Griffith at the state board, and with the understanding that they would be emailed to her, and I did email them to her, and that they would be accepted timely because I did not receive them until March 13th, according to the certified mail. I think it's kind of dirty business for Clark County to send out in the mail notices of decision of the County Board of Equalization on March 9th, very well knowing that the deadline to file these appeals is on March 10th.
County or board, do we have any questions for the representative of the property owner?
None here, Mr. Chair.
Al?
No, I'm fine, thank you.
Tim?
Not at this time.
Assessor, it's your opportunity to make your case regarding jurisdiction.
Yes, Mary Ann Widener with the Clark County Assessor's Office. The first thing I want to note is the county assessor has no control over the county clerk. The county clerk has to process all of our paperwork and all the documentation from the hearings, and there's no time frame for when that has to be completed. They just have to complete it, and they do send the final notices of the conclusions to the petitioners at that time. But I will say that all of the information that agents receive from our office, I know in the earlier hearing we were asked about what we do send them. We do send them agent authorization forms. We send them instructions for filling out authorization forms. In those instructions, it gives the deadline for filing to the county and the state, and the statutes behind that. At the hearings, the chairman at the County Board of Equalization also says if you do not agree with the decision that was made at the county, we have the forms in the back of the hearings where they can fill out the forms right then and there on that very day when they if they disagree with the decisions of the hearings. This particular agent chose not to show up at the county board hearings, and so they were not there to hear that, but at the same time they could have been there if they chose to be there. And that doesn't negate the fact that the statutes are the statutes that say that the filing to the state must be done by March 10th. The hearings completed at the end of February, and so there was a good 2-week window for them to go ahead and file these appeals if they wanted to file them after the hearings closed for the county board. And that would just be our argument with regards to timely filing. We think that timely filing is a pretty straightforward requirement by the statutes, and that there was plenty of time for that to happen, and they did not have to wait to get the information back from the clerk to do so.
Board, any questions?
I'll just provide a comment. I have seen at a county board meeting where every case that is adjudicated, that information is put out by the chairman, and the forms are provided as the petitioner is walking out of the room. That has essentially everything that the county was just explaining. And this is not in Clark County. This was a different county that participated in, and that was standard procedure.
Yeah, I have a question of the tax agent. Were you aware of the decision when the county made it, County Board of Equalization? Were you aware of the decision since you weren't at the hearing? When were you made aware of what the decision was?
I was made aware of what the decision was at the Board of Equalization when I received the notification in the mail on March 13th. And I'd like to say that I am the Circle K National Agent. I filed in 29 states this year in about 1,600 counties. And yours is the only county that I'm having this issue with.
So to reiterate what Tim had, Member Morris had said.
The board told me that they would be accepted. I spoke with her, and that's why I emailed this in on that day.
To reiterate, go ahead, Tyree.
Mr. Chair, you might actually be getting ready to say what I'm going to say, so I'm going to listen to you first, and then
Nope.
I'll chime in.
It's generally my policy to allow the board, with certain exceptions, to precede me.
No, well, thank you, Mr. Chair. I appreciate that, and I will do so. I guess following up to Tim's question is to, and this is to the petitioner, Circle K, is it your testimony on record that you had no notice of what the decision of the Clark County Board was prior to receiving this notice in March? Is that your testimony that you're presenting to this board?
Yes, sir, that's correct. And I provided on page 5 the certified mail receipt of the actual envelope that was sent from Clark County to notify me of the results of the hearing.
And then, in addition, Mr. Chair, if you'll allow me one follow-up, Tyree Gray again for the record. And then there was a decision to not attend the county board to where you could have been there to actually hear the resolution and or participate as well. Is that correct?
I have sometimes 5 and 6 hearings a day in different states. So yes, I had thorough discussion with, I believe it was Kevin Cole at the assessor's office. And I was under the impression that they were reviewing the evidence that I had sent in, and that would be in a discussion at the county board hearing at that time. But as I've recently spoken to him, he said that either he lost the evidence or he didn't get the evidence when I filed the appeal, and he did not review that evidence prior to the county board. And in fact, when I was preparing for the board hearing this week, I spoke with Daryl Prowaski, and he told me that it wasn't the responsibility of the county board to forward my evidence to the board. So my evidence just made it to the board yesterday. So from what I've seen, I fairly agree with Mr. Goldapp in his statement earlier today that Clark County doesn't believe that the statutes really apply to them. And I'd really like to have an opportunity to discuss the issues for each of these 24 cases before the state board, if you would so hear me today. And I would appreciate that very much.
Thank you. We appreciate your position. I guess my question is that your testimony is that you had conversations with the county, with county employees. You had notice of the fact that the county board was going to be hearing your case, and a number of weeks passed by without any continued discussion with any of the county staff or anything like that, and then you received notice several weeks after the fact, and that notice wasn't received until after the deadline. But were there any attempts to try to find what the resolution was between the hearing and receiving that notice?
Usually all of those notices are either emailed to me or uploaded to a shared system online, but that does not happen with Clark County. So yes, my only other alternative is to receive the notifications in the mail.
Okay. Thank you, Mr. Chair, for indulging me. No further questions.
Thank you, Board. Any other questions or comments before we close the hearing for deliberation?
No, sir.
Is there a couple comments? Daryl Pawalski, can I add a couple comments as far as a rebuttal or?
Sure.
All right, it'll be real quick. So the first thing I wanted to mention that the clerk, when they send out their decision letters, they don't mention anything about a further appeal process. It just says this is the decision that was rendered at the county board. Our cases can run all the way up to the 28th of February, and March 10th is within a pretty short window to get this notification. So I think a lot of taxpayers would probably not be noticed until after the board hearing. But we are very diligent in including additional information, frequent questions about the appeal process and the appeal form when it is sent out. And it does state specifically on there if they do have any some rights to appeal to the state board by March 10th. And these deadlines are also available at the state's website on their forms. I have not had conversation with the appellant except for the last 2 weeks. So the evidence that she's talking about that she's been submitted to us, aside from some agent authorization forms that were sent in on some of the leases on some of these properties that aren't owned by Circle K but leased from Circle K. Those have all been very recent comments. My understanding is there's been little to no communication with the appellant in the county proceedings. Didn't hear anything, didn't see any information. They made their ruling that we were not exceeding taxable value. And like I said, my conversations with her were just a couple weeks ago.
Some of that relates to the nature of the case. At this point, it's merely hearing discussion regarding jurisdiction. I will close the case for deliberation. Tyree, you've been somewhat vocal in this case. Do you have any discussion related to deliberating on whether we should accept jurisdiction?
Thank you, Mr. Chair, for the deference. It is my opinion that actual notice is important in order to allow a taxpayer to make a decision in regards to whether or not they should file an appeal. Actual notice could have come by the taxpayer attending the hearing. And I understand that the taxpayer is busy, runs a national business, and I'm certain that employs a lot of law firms and consultants throughout the country that may or may not have been available to actually attend the hearing. My concern is that if this were in a lay person situation, a true lay tax person, receiving a notice after the filing deadline would be of concern. And though I consider the taxpayer to be a sophisticated party, I believe that we should always act in a way that is, most broad and advantageous to the taxpayer if they were a layperson. And so receiving notice after the fact of after a deadline, I think is problematic and would lead me toward being willing to possibly accept jurisdiction, but I'm willing to hear what others have to say and be persuaded otherwise, potentially.
Al or Tim?
My thought runs along part of what Tyree just said is we are talking about a sophisticated taxpayer who had opportunity several ways to understand what the deadlines were and comply with them. I'm going to have to give that some more thought, but it just, the resume of this representative is pretty extensive and seems like there would have been more attention paid to making a filing deadline. I don't know if the state of Nevada is any different or Clark County is any different than the other jurisdictions, but I wouldn't think they would be substantially different to where there wouldn't be a formalized process of either attending the county level or requesting the results of that hearing. Especially with this number of cases, it's got to be no small dollar amount.
I have a question. Was this meeting on Zoom?
Mary Ann Widener for the Clark County Assessor's Office. No, all of our hearings are in person.
Is there accommodation made at all to accommodate people who are unable to attend physically?
The only accommodations that we do make is if they want to have someone represent them, they can have someone come and represent them. We will reschedule hearings if necessary because of something that's caused them to be able to miss a hearing. If we're still within the window of our having to have all of our hearings completed by the end of February. But this particular person has filed in the past and has we have been given notice in the same manner in the past, so we're just following the law. Thank you.
I'd just like to mention that this is the very first ever filed appeals with Clark County, Nevada.
I'm sorry, I did not hear you.
I just wanted to mention that this is the very first year I have history of my career filed appeals with Clark County, Nevada for the Circle case, or ever.
Chairman, I'm sorry, I was just reminded by our district attorney that there are links available on the Clark County website where you can actually view the hearings. You can't zoom in and respond like folks here today are able to do, but you can actually view the hearings from other locations and see the results of the hearings. They are televised, and they're available on the links on our Clark County website.
How long after the meeting is the results posted on your website?
We don't post the results from the meeting on our website. We've never posted the results of the meeting of our website. I mean, we do update our records if there's reductions, and we usually do that within a very short window because we have reports that have to come to the state. So if there is a reduction that's in order, it does get changed and posted to our website in a pretty quick order. But there's nothing else beyond that. I mean, the biggest crux of the concern here for Clark County is that, you know, tax reps are very aware of we've informed them of the law, and I'm just concerned that we're not abiding by the law and we're going to bend the law based on various things that really have nothing to do with the requirements. And so that's our biggest concern, you know, when a taxpayer comes forward and says these things, because the statutes are clear that the deadline for filing is March 10th. And there is enough information out there to let them know that that deadline is March 10th. And there's nothing to prevent them to ask the question or attend the hearing. They should attend the hearing. If they filed the appeal, they should attend the hearing if there's an appeal that's been filed. But if they choose not to attend the hearing, then I would say the onus would be on them to find out the information, because it's all there and available and it's in public site. Thank you.
Lisa Logston with the Clark County District Attorney's Office, just to add, and that site can be accessed after the meeting, I think, to your point. Just because the meeting is concluded, it's still available. I mean, I think we can go back and watch hearings back from 2018 or even further back than that.
Boy, that would be super exciting.
I had the privilege of doing that just last night or night before last. I went back and watched one of the county meetings. It was.
If it's riveting.
It was very important to the matters on the agenda today, Mr. Chairman. I tend to agree at this point. I think that we are dealing with a sophisticated property tax representative that should have been aware of the results of this of the county board action. The information was available according to the assessor's office, and that they could have monitored the meeting or were able to find out the results rather quickly without having to wait for it to come through the mail. And therefore, I make a motion that we deny the petition. We do not take control or access or hear this jurisdiction. I'm sorry. Thank you. We deny the petition and do not take jurisdiction.
Do I have a second? Al or Tim? Have we lost both Al and Tim? Or Tyree, I'm sorry.
No, I'm still here.
Do I have a second, or is there a different motion that you would like us to consider?
I guess I just have one more question. How long? When was the appeal received from the taxpayer?
This is Christina Griffith for the record. We received the appeal on March 15th.
And the filing deadline is the 10th, March 10?
That is correct.
March 10 was a Friday. The 15th is the following Wednesday. Do I have a second or a competing motion?
Mr. Chair, this is Tyree Gray. For the record, I guess my hesitance in I should say my thoughts for the record, if I may. We are dealing with a sophisticated taxpayer. There was an opportunity for the taxpayer to participate at the county level, and the burden of proof would have been on the taxpayer at the county level, and the taxpayer appears to not have participated at all. And so it is noteworthy that there was no participation at the county level, and then there was no due diligence placed forward to actually find out what happened at the county level, but then to kind of come to the state board in search of relief when there were opportunities available to the taxpayer. And so for that reason, I will actually second Tim's motion that we should not accept jurisdiction, because I am persuaded that the taxpayer had opportunities to gain actual notice and to actually have been able to follow the law before receiving the form notice that was mailed out.
So I have a motion and a second. All in favor signify by saying aye. Aye.
Aye.
Aye.
Aye.
Any opposed? Hearing none, motion carries. I want to add for the record that the way that this series of appeals had been presented, it appeared that the taxpayer would request or implied that they wanted us to be the initial jurisdiction. This case, this series of cases would have been best heard in total at the county level. To come in and suggest that the state board be the primary jurisdiction, I think, is taking some liberties that are inappropriate. What I'd like to do now is just read the case numbers that this motion applies to. All of them are 2023 cases. Kelly, if you could just verify as I go through this list. It's case 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 161, 162, 163, 164, 165, 166, and 167.
That is correct, Chairman.
So with that, we have dispensed with item D on the agenda. It is 11:45. It's my impression that there may be extensive discussion related to the upcoming cases in item E. And I might suggest that we take a break now for lunch and reconvene in an hour or less. So I will see you all here. I will see you all here at 1:45. 1:45, or 12:45, depending on your perspective.
Recording stopped.